We've talked a lot about the United States Supreme Court decision in United States versus Rahimi. Let's talk about a big question that keeps coming up. What does this mean for so-called red flag laws, gun confiscation orders? Well, we're going to talk a little bit about it when we get back. Don't miss it. Come on back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed. What the 10/7 attacks on Israel teach Americans about the right to bear arms. Check it out on Amazon. All right, folks, so we have to it's very important that you understand the United States versus Rahimi decision. There's a lot of propaganda out there by the anti-gunners, a lot of myths being made by people that, want to criticize the majority opinion. And I understand all that. But remember, as you know, I'm not here to just sell you rainbows and unicorns. I'm going to tell you what I think is really going on here. And I want to do it in the context of a very, very important topic near and dear to all of our hearts. And that is preventing red flag laws or gun confiscation orders from taking over the world and allowing nutty anti-gun people who live next door to you to take away your gun simply because, let's say, you fly the American flag upside down or whatever. Okay, so let's talk about what this means. Now, remember, there's one theme that we have worked on quite a bit over the last 6 to 8 months, and I really emphasized that if you want to be a Second Amendment guru, and it's my goal for you to be the smartest people in the room when it comes to your Second Amendment rights, there's two things you have to understand. There's the substantive law of what the Second Amendment means. The right of the people to keep and bear arms shall not be infringed. What does that mean? What are the exceptions based in history, if there are any? What does all that mean? That's substantive law. Like, what causes you to be convicted of murder? The law against murder is a substantive law. But then there's another thing that we've talked a lot about, which I'm really trying to teach you is very important, and that is the process, the procedure, the way a case goes from the start of a lawsuit or a criminal case through some sort of remedy or adjudication, penalty, sentencing, whatever it is. The womb to tomb of a case. The process of a case from womb to tomb is the process or the procedure. Now, the reason why I'm harping on this difference between substantive law, i.e., what does the Second Amendment mean and how does it apply, versus process and procedure, i.e., how a case works its way through the court system, is because this issue is extremely important for you to understand in the context of discussing so-called red flag laws or gun confiscation orders. You really need to understand this in this particular context more than anywhere else when it comes to our Second Amendment rights. And here's why. Okay, to begin with, let's talk about substantive law, and then we're going to talk about what I think is really the most important thing when it comes to red flag laws, and that is the process or procedure. Substantively, I've told you before, and the Supreme Court has vindicated what I said. Whether you like it or not, and I think you should like it if you support the Second Amendment, if someone has been found in a court of law after robust due process to be an actual violent danger to themselves or to others, they can be disarmed and or they can be locked up. They can be locked up in prison if they've committed a crime, or perhaps they can be locked up through civil commitment processes in a mental health institution. And by the way, let me step back for 1 second. If you support the right to keep and bear arms like I do, it's going to sound counterintuitive, but hear me out. If you support the right to keep and bear arms like I do, it's extremely important that we recognize and support the notion that truly, undeniably violent thugs, terrorists, evildoers, actual violent, dangerous, bad people that are in our midst, we know they exist. We have to make sure that they are locked up either in mental health institutions if they're mentally psychotic, which happens. They may not know what they're doing, but they're still violent. They got to be locked up. Or if they've committed a crime, a violent crime, rape, robbery, murder, evil, malum in se crimes. The reason why it's so important to try to get these people locked up, take away their guns, get them out of society, is because it is this category of people that are the greatest risk to the Second Amendment in the United States. Did you hear what I just said? It is the psychopathic nut jobs. And the violent criminal thugs, the terrorists, and so on, gang members, that pose the greatest threat to your rights and my rights to exercise a right of the people to keep and bear arms shall not be infringed. And the reason why I say that is, whenever these nut jobs or criminal thugs go out there and they shoot up a school, they commit a mass shooting, they murder a bunch of kids, they shoot up a carnival, they shoot police officers, whatever it is that they do. Whenever these people are out there doing horrible, terrible things that gather headlines, guess what? This gives the anti-gun movement in America the opportunity to point and argue in favor of more gun control against law-abiding Americans. Now, you and I know that's not how it should be done, that if some nut job defames someone or commits fraud by virtue of what he says or writes, that should not infringe upon my right to free speech. If somebody uses religion to, promulgate a terrorist attack in the name of a god that they support, that should not be a basis for me to lose my ability to pray, go to church, let's say. Likewise, if someone goes out there and uses guns to commit a heinous act, that should not be a reason for me to give up my ability to protect myself, my family, my friends, my community. Nevertheless, the reality is when these terrible things occur by nutty psychopaths or violent thugs, it does endanger our rights because it allows the anti-gunner and the gun control movement to point to these events and to say we need to restrict guns. So we should want, as a general matter, bad people, violent thugs, to be locked up, either in mental health institutions if they're mentally psychotic and they're not there upstairs, or in prison. Okay. With that context said, let's talk about red flag law specifically. There is no way, as I predicted, that the U.S. Supreme Court is going to say that it violates the Second Amendment if someone is found in court after a hearing and due process to truly be a violent danger to himself or to others, to be able to have a gun. Okay? If you're found to be a violent danger, they're either going to lock you up in a mental institution or in prison. Then the Supreme Court's going to be like, that's fine. Okay? That is what we have to understand is the baseline for our rights. If that occurs, they're going to get locked up, and in my view, in many instances, we should support that. Now, with that said, what does this mean for red flag laws? So let's go back to the big picture. There's two lines of things you got to understand. The substantive law. On the substantive law, substantively, the Supreme Court is not going to say that you lose it violates the Second Amendment to take away guns from violent terrorists or gangbangers and or from people that are mentally psychotic and dangerous to themselves or others. The Supreme Court, I don't think substantively, now we're going to get to the process in a moment. Substantively, they're not going to stop that from taking place. They didn't do it in Rahimi, and Mr. Rahimi was involved in 5 shootings after he had already agreed that he engaged in a violent attack on his girlfriend and subjected himself to a restraining order and admitted he was a credible threat to violence to others, and he still engaged in 5 shootings after the entry of that restraining order. That's how bad Mr. Rahimi was that gave rise to the Rahimi decision. Now, again, that's the substance. So what do we do to fight back against red flag laws? Because the answer is, it's not about conceptually that they're always unconstitutional under the Second Amendment. The real fight, in my view, about red flag laws is always about making sure that there's adequate due process procedures and protections that have to be followed by the government to take away our fundamental right to keep and bear arms. What do I mean by that? If you think about it now in the two analogous contexts, and by the way, this is consistent with what the Supreme Court said in Rahimi. Remember, the Supreme Court upheld 922G8 that says if you're subject to a domestic violence restraining order after a finding that you're a danger to someone else, that's consistent with the Second Amendment. And they did so based on looking at 2 things. Criminal punishment laws, criminal penalties, criminal laws, known as the affray laws, which basically said that if you were a public danger to others, you engaged in rioting, mob violence, whatever, criminally, you could be put in prison, and obviously you would be disarmed in prison. And then they looked at the preventative justices, that was the criminal laws. Then you looked at the preventative justice laws, the surety laws, that said that if you were found to be in court a danger to someone else, they could force you to post a bond and get sureties. And that was a civil process at the time of the founding that was ubiquitous. That was really a version of preventative justice. So again, the affray laws were criminal justice. You could go to prison for violating the criminal law. The surety laws were civil preventative justice remedies like a restraining order. And those were ubiquitous as well. So with that said, let's talk about what red flag laws really are. The reality is the anti-gun movement, and no one's written more about this than I have. I've written extensively about why I hate red flag laws, and I absolutely hate red flag laws. But the reason why I hate red flag laws is because the anti-gun movement in America wants to use red flag laws and their sound good nature to get around the due process protections that are always in place if government wants to take away other fundamental rights. For example, if they want to lock me up in prison and take away my ability to move around the society freely by taking away all my rights, by locking me up in prison, there has to be a robust due process, a trial, lawyers. If I can't afford a lawyer, they appoint a lawyer. Same with experts. There has to be a full-blown criminal process whereby my rights are protected every step of the way, and the burden is on the government. That is what happens if they're going to take away my right to freedom and lock me up in prison. Whole bunch of due process rights. Likewise, and this is key, in the context of civil commitment procedures, where if you are involuntarily committed to a mental health institution after a full-blown trial, same concept. There is a trial, you get lawyers involved, there are experts. If you can't afford them, then the government is to provide these things, and you cannot lose your right to freedom by being locked up in a mental health institution absent a massive amount of due process. So you got massive due process to be locked up in prison if you've allegedly committed a crime. You've got massive amounts of due process under so-called Baker Acts, which allows you to be locked up in a mental health institution on what's known as an involuntary meaning against your will, involuntary civil commitment process. Now, those are the way that it's worked for many, many decades. And people are generally fine with all this. The due process is generally acceptable. These procedures are in place. Everyone understands what they are, and they're very protective of individual rights. The red flag laws, of course, the anti-gunners want to skip over the process associated with putting someone in prison under the criminal laws. And they want to skip over the process associated with making sure your rights are preserved before you go get locked up in a mental health institution in a civil commitment process. They want to skip over all that and just take away your guns. Do you see? So the right fight for us is we want to argue that in the red flag context, you can take guns away from people that are truly violently dangerous if and only if you give them the same amount of due process protections they get before you lock them up in a prison for crimes or you lock them up in a mental health institute for mental problems because they're violently dangerous toward themselves or others. If you don't have that process, you can't take away people's guns under red flag laws, which are nothing more than attempts by the anti-gun community to shortcut the process. And this is why it's so important to understand that the Rahimi case, in one sense, reaffirms what we always understood was going to be the law, that the Second Amendment is not going to prevent people from being locked up and disarmed if there's a finding that they're a danger to themselves or others, either civilly or criminally, after a robust due process. Now, the reason why due process doesn't come up in the Rahimi case is because there was no due process challenge. Mr. Rahimi waived his due process rights, among other reasons, because he admitted to everything and said, and he didn't challenge it. He didn't disagree with it, and he never raised due process until it was too late. So the Rahimi case lays out the law of substance, which I think we all understood was going to be the law, but they don't speak about due process. And the due process is where the rubber is going to hit the road in red flag cases. It's all about the due process. If you make the government actually make an individualized finding that you are dangerous after a full-blown trial with experts and lawyers and the cross-examination of witness and the disclosure of medical records and all this stuff, and you're found to be a violent danger to yourself or others, you likely are. Okay? That's just the reality of it. But the reality is what we're trying to protect in the red flag law context is the reality of your neighbor complaining about you because you're in a fight over where your property line begins and ends. Someone is angry with you because you broke up with them with a text message, right? Your ex-wife is trying to get your custody over kids and wants to apply leverage against you by trying to get a restraining order and take away your rights and so on without a finding that you're actually a danger. These are the sorts of things that red flag laws have to be, carefully construed and applied. But again, the way to win those red flag laws is going to be process and due process and procedures. And what we want is to make sure that the process and procedures that protect our rights are the same that we see in criminal cases and in civil commitment processes. That's where the rubber is going to hit the road. So in one sense, Rahimi does advance the ball for red flag laws, but it doesn't advance the ball in any real respect, because there is always going to be the case that if you're found to be a danger, you're going to be disarmed, locked up, put away. That was just the reality of it. It's just the reality of it. Okay, but that's not the big issue. The fight about red flag laws has never been about that. The fight over red flag laws is always about due process, procedures, protections in the method in which you are ultimately found to be a violent danger. So again, Rahimi deals with substance, but the red flag, rubber hitting the road, is all about process. Don't lose sight of this. When we talk about red flag laws, it's all about the method, process, procedures of fighting these cases. The burden is on the government. They can't take away your rights unless, at least beyond clear and convincing evidence, you're a danger, and so on and so on. So that's kind of where it is. The other thing is, in some ways, Rahimi does help on the red flag case, because they're not going to be able to take away your gun rights if they simply find you to be not responsible. Because remember, Rahimi says, the Supreme Court says in Rahimi, that the standard is not that you're not responsible. They can't disarm you if you're simply not a responsible American. If you're irresponsible American, that is not a basis under the Second Amendment to take away anybody's rights. You have to be found to be a credible threat of violence to third parties, which, by the way, was exactly what I said was going to happen, and that's exactly what happened. So if you've been watching this channel, none of this should be a surprise to you, like it or not, and I think you should like it, because the reality is we have to take guns away from the nut jobs and psychos out there, because it's the Adam Lanzas of the world that shoot up Sandy Hook that cause the gun community to have all sorts of problems. So we need to at least be sensitive of the notion of locking up bad people and people that are mentally ill to the point where they're dangerous to themselves and others. That's just the harsh reality of the society we live in, and I think you should just be aware of that. Again, let me know if you disagree. Feel free to attack me down below and criticize me if you feel the need. Tell me if I'm missing something. I'd like to hear it. And again, don't forget to follow me on X at 4Boxes Diner, and make sure you subscribe, and we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.